In this video, we explain the Constitution Amendment to regulate the first session and inauguration of members-elect of the National and State Houses of Assembly signed by the President in March 2023. This act alters sections 54, 96, and 311 of the Constitution to prescribe the quorum for inauguration and first sitting of a new assembly and mandates the use of existing standing orders of each legislative house at the inauguration. In particular, the amendment stipulates that the quorum required for the inaugural and first sitting of the Senate, the House of Representatives, and State Houses of Assembly shall be at least 2/3 of all the members elect. The Act further provides that an outgoing Assembly's standing orders, that is, the rules guiding legislative proceedings, should be used for the first sitting of the Assembly, but can be modified later. Quorum here refers to the total number of members of a legislative assembly, chamber, or house that must be present to constitute a meeting of that house. Until now, there was no distinction between quorum for a first sitting of the House and subsequent sittings, but this amendment has introduced this distinction. Principal officers, such as the Senate President and Speaker, are usually elected at their first sitting, so what this amendment does is to ensure that a majority of legislators, at least 2/3, are present at the inauguration to elect their principal officers. Another amendment to the Constitution in Section 311 provides that the standing orders or rules of the Senate, House of Representatives, or State House of Assembly, as the case may be, which was in existence before its dissolution, shall apply to the proceedings of the first session of that assembly, but can be modified later. This would ensure that the rules used for the first sitting and election of principal officers are not arbitrarily changed to influence the election.